Well, my first thought is when the prosecution asked the question about the defendant's demeanor and what the witness said, I wanted to know why she felt that way. I wanted to hear more information about it. Why was he standoffish? Why did she think he was standoffish? And I was interested that the prosecution didn't ask the next question. But then they had the sidebar. So we're going to have to see if the prosecution revisits that issue as well. But I think the prosecution is doing a great job. They're very succinct. They're telling a story. They're going through the witnesses, giving the background, giving them credibility, and doing an excellent job in really representing the state well.
And, to that point, it's my understanding that the Monroe County prosecuting attorney, and that's Tally Smith, and she is the one, you can see the very back of her furthest away from the judge in his chair, is known as and has a reputation as an efficient prosecutor. She doesn't believe, from what I understand, of wasting tax dollars and of not doing a thorough sifting, but yet efficient job. And I think that I would echo that they have certainly prepared, it appears, to be efficient in the presentation of the evidence. Now, what are your thoughts about, Julia had really great insight about this defense attorney is asking few questions, but maybe most pertinent, the questions that he believes are the best for the defense. And it's moving this trial along. Tell me your perception or observations or experience from the defense attorney's perspective.
Yeah, it's really interesting. I try to think, why is he asking certain questions? Like when they had one witness on the stand asking about the bullets of the gun, saying that, anyone could have that, to help substantiate the fact that these could be, anyone's bullets, that it necessarily wasn't the client, that it could actually be someone else. But when they had the person that did the marriage certificate and he asked about the extension, I had absolutely no idea why he was asking that question or the purpose of the question. And so why would he ask about an extension? I'm trying to see how that's going to help his case or prove. But the state has a burden of proof, and so we'll have to see. But as I said before, the state's doing a great job.
And what was interesting, because that question appeared to be one he didn't know the answer to, which as trial attorneys, we know that can be a dangerous, slippery slope place to go. Because when he asked if there could be an extension or not, he said, well, I don't know. I'd never really been asked that before. I don't really know. So it's been interesting to watch. And what do you think in terms of the circumstantial evidence that we expect, A, that have been heard through 7.5 witnesses at this point, and B, that we expect to hear throughout the duration of this trial, and whether or not a jury is going to believe that there's no reasonable doubt that it had to have been this defendant who shot Molly Watson in the back of the head?
Right. Well, I'm a strong believer in our system, our judicial system, and I believe that the jurors will listen to the evidence and based on the evidence, make a determination. But like you said, the prosecution has the burden of proof, and they have to prove the case and have to substantiate that the evidence will show. And if there's enough evidence and the jury believes that they've proven the case and that it couldn't have been anyone else, then they could come back with a guilty verdict. Where ultimately, we're going to have to see what other witnesses come forward and what other evidence the prosecution brings.
Absolutely. I completely agree with you. I believe in our system as well, and juries tend to get it right, and it's their job. And I haven't met a jury yet who didn't take that job seriously. Kelly, we have a great team here at Court TV, and someone asked or pointed out something pretty significant in my mind, which is when the witnesses have been identifying the defendant, the court has not asked the defendant to lower the mask. Now, I know that I see people and don't recognize them until they lower their mask, and then I say, I apologize, I didn't recognize you with your mask on. Is that something that's of any concern to you? Is that a potential appealable issue in the witnesses identifying a defendant who's wearing a mask?
Oh, that's an interesting argument. I mean, if the witnesses, though, testify that based on what they observe, that they can see the fact that that is the person. Now, would the prosecution say, ask to take down the mask to verify that as well? There might be some issues as well. But the fact that they're, identifying the person, I mean, the defendants could make the argument that that's not the person, but I don't see that happening. Maybe there's some other reason the defendants will, if there is a conviction, file an appeal based on something else during the trial.
All right. So let's go back into court. We still have the court. I was just looking on my screen to see what was happening, any movement, any action. A very long sidebar. But again, the times that I've observed during today, throughout the first day of trial, a sidebar or a proffer, this judge engages, has conversation about the issues to make sure he understands what the evidence being presented is or the legal argument is. He then weighs in, they go back and forth. There's also, and this is not a bad thing or a good thing, but watching trials, conducting trials, a little bit of a more casual atmosphere that we're observing in this courtroom in terms of the attorneys. You know, one viewer commented, the attorneys are laughing. How can they do that during a proffer when the jury wasn't in the courtroom? And while I understand that when you watch a trial, it may seem unprofessional or frustrating or wrong, the reality is these are attorneys who may know each other, may have worked together before, and they may just be showing, you know, the personality, the reality of how they act in a given day, not taking away from the seriousness of the allegations, but just the reality of being at work. Let's go back to court.
All right. What we're going to do is take a break for the evening, and then we'll work on this while you're breaking. All right, ladies and gentlemen, I would be remiss if I did not remind you that what you were told at the first recess of court: until you retire to consider your verdict, you must not discuss the case among yourselves or with others. Permit anyone to discuss it in your hearing. Do not form or express any opinion about the case until it's finally given to you to decide. Do not do any research or investigation on your own about any matter regarding this case or anyone involved with the trial. Do not communicate with others about the case by any means. Do not read, view, listen to any newspaper, radio, electronic communication from the internet or television report about the trial, including but not limited to Google, CaseNet, YouTube, and Court TV. Will be in recess. We'll start again at 8:30 in the morning. Thank you. You may follow the marshal.
Day one in Missouri versus James Addie has concluded. They are on recess until tomorrow morning. You will continue to get your live coverage, continuous live coverage here on Court TV. Don't go anywhere. Up next, Michael Ayala joining you.